Good evening and welcome to Cheltenham Borough Council Licensing Subcommittee Alcohol and Gambling, being held on Wednesday the 27th of May 2025. My name is Councillor Simon Wheeler. I have been elected as Chair of the committee. This meeting is being streamed live to Cheltenham Borough Council's YouTube channel, and the recordings of the meeting will be held for 4 years. If you are, if there are any breaks in transmission the YouTube stream, the meeting will be adjourned for a short period until any issues are resolved. If you are here to make representation to the meeting, you are consenting for the use of the sound and video recordings for broadcast and training purposes. Please be aware that CCTV and audio recording is now in operation in the public gallery. The recordings will be held by the council for 5 months. And please note a fire alarm test is not expected. So if the alarms do sound, you should immediately make your way to the nearest exits to our right here. Sorry, to my right, to your left. If there is an emergency and we do have to evacuate the building at any time, you will be taken to the nearest exit with a member of staff. Right. Agenda apologies. There are no apologies. We have a full committee. Declarations of interest, I don't believe anyone has. I'm seeing shaking heads, so nobody has any declarations of interest. Determination of a new premises licence. Sorry, it's agenda item 4, sorry, but yes, beg your pardon. Because this is a regulatory item, members must be present and have heard the proceedings in their entirety to vote on the items. We will ensure that the applicant and the applicant's representative, if they have one, are present in the meeting, which I think is the case. I will ask the licensing officer to introduce the report. Members will get the opportunity to ask the licensing officer questions. The applicant will then get the opportunity to ask the licensing officer questions. The objectors will be given the opportunity to speak and ask, and we ask you to limit your time to 10 minutes. The applicant or their representative will be given the opportunity to present their application or make their case. Members can ask the applicant questions. Members will debate the matter. Then the applicant will give given the final right of reply, and then the members will retire to make our decision, and then we will return and explain the outcome. So I would like to invite the Head of Public Protection to introduce the report, please.
Thank you, Chair. Thank you, Chair. Just to clarify, I'm the Senior Licensing Officer. And here we are today to determine an application for a new premises licence for McDonald's at a former site of TGI Fridays located at 374 Gloucester Road. The application is for late night refreshment, Monday to Sunday, 11 p.m. to midnight. To clarify, late night refreshment is the sale of hot food and or hot drink between the hours of 11 p.m. and 5 a.m. And this is the only licensable activity McDonald's have applied for. No licensing consents are required for McDonald's to operate between the hours of 5 a.m. or 11 p.m, and so members should make their decisions in determining the application with consideration to the hours included in the application only. Similarly, if members should choose to attach conditions to this licence, these conditions can only be applied for the hours the applicant has applied for. No representations have been received from any responsible authorities. A number of representations have been received from members of the public and are attached to the report as Appendix 2.1. A representation has also been received from Councillor Dr David Willingham and has been included as Appendix 2.2. A number of objections reference matters which we are unable to take into consideration as they are not licensing matters. For example, issues regarding planning cannot be considered, including any potential impact the location of this premise may have on traffic, which would have been assessed by the planning team. Representations which can be considered are representations which address the licensing objectives, which are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. In relation to public nuisance, it should be noted that whilst we didn't receive representations from responsible authorities, we did receive a response from the Environmental Protection Team, which did confirm they had no comments regarding this application, which would suggest that they have no concerns surrounding noise nuisance. As guidance, we do have a licensing policy statement, which does allow core hours for different licensable activities. The licensing authority generally believes that a restaurant premises would not have a harmful impact on the licensing objectives with a terminal hour of up to 1 a.m. So the application is within the timeframe our licensing policy statement recommends as appropriate. Though it's perhaps worth noting we don't have takeaway premises, it is just restaurant as the closest premises type. The committee must determine this application on its own individual merits with a view to promoting the licensing objectives. Licensing conditions will be tailored to the individual application, and only those necessary to promote the licensing objectives will be imposed. Worth restating at this point that we can only do so for the hours of 11 p.m. to midnight. The committee must have regard to all of the representations considered as relevant and weight the evidence as it sees fit. After it hears all of the relevant evidence, we will then determine the application. The subcommittee has 3 options in front of them. They may grant the application as applied, modify the conditions attached to the licence, or refuse all or part of the application. Any questions from committee members?
Any objections from objectors? Questions, sorry. I think Councillor Willingham would just beat you to it. Okay.
Sorry, I was a bit unclear what you said. You said about takeaway is not included in this licence, or is takeaway included in this licence?
So sorry, just to clarify that point, there's a licensing policy statement which was been produced by the council, and that sort of lays out a list of hours for different premises types, which we would suggest would not impact any of the licensing objectives. There is no suggested hours for takeaway premises, but there is a suggested set of hours for a restaurant premises. And the council believe that a restaurant premises should be able to open until 1 a.m. without negatively impacting the local area.
Councillor Willingham.
Thank you, Chair. I've got 4 questions. So the first one is, as a licensing professional, are you familiar with either the LGC Forensics or Callagate certifications for CCTV that are specified in the applicant's operating schedule? And if so, could you provide an overview of what technical features and assurances they provide, please?
I can say, no, I'm not aware of the Callagate certification, I'm afraid.
Thank you. There's the second one, which probably is a moot point given what you said, but if the operating schedule was turned into conditions that required one of these systems, as a licensing professional inspecting the premises, would you be able to confidently and independently verify the CCTV system to determine whether it was compliant with these certifications or not?
It would be one for our enforcement officers to assess, I suppose, when it comes to it. Ultimately, it's a workable operating schedule as it does lay out a set of conditions. It's for members, I think, to address this with the applicant themselves and perhaps fine-tune some wording to make it perhaps a bit more enforceable.
Thank you. Third one, given that both licensing and environmental health all sit under the public protection umbrella in the council, are you aware of any dialogue between the applicant and environmental health to discuss the various partnership working situations which are mentioned in the applicant's operating schedule?
No, not I'm aware of, no. When the Environmental Protection Officer replied, it was just to state that they had no comments to make regarding the application.
Thank you. And finally, do you accept that in law, a child is anyone aged under 18? It's possible to get a moped licence at the age of 16, a driving licence at the age of 17. And therefore, would you agree it's not unreasonable to expect unaccompanied 15, 16 or 17-year-olds could attend the premises during the licensable hours, and thus their needs need to be considered in terms of the protection from harm licensing objective?
As far as a legal listing goes, it might be best deferred to the legal officer, this one. But I would suggest, also happy to defer to my boss.
Oh, there we go. Thank you, Chair. I was just going to say that under the Licensing Act, a child is under 16 years of age and a young person is over the age of 16 to 18. Thank you.
Thank you.
Are there any other questions from objectors? Or, okay. Right. Has the applicant got any questions for the licensing? No. Thank you. Right. I'd like to ask objectors to address the committee, please. So, sorry, where am I?
Unfortunately, we've had a no-show
Right.
so we've now got Mr. Martin Lee is here.
So, Mr. Lee.
Hey, good evening. I'm Martin Lee. I'm a resident nearby, about 50 to 100 metres away from the planned site for McDonald's. As mentioned, I'll keep mine brief, but residents are concerned about three main things we've already brought up: the noise being a potential problem, as well as the antisocial behaviour that we could expect from any new premises, as well as litter, which was already a problem in TGI Fridays, which has become, which we anticipate to become a bigger problem. Whilst we're at the beginning of the proceedings, I'll await to hear some of the responses we have to those concerns we have, because our particular observation was that we were supposed to be replacing like with like, with a TGI Fridays restaurant that's now closed down with a takeaway that seems to be expanding as well and pushing new boundaries.
Thank you. Rowena Kay?
No.
No, not here. Anthony Hopkin? It's just David.
Hi there. I apologise, I've not got a prepared speech or anything. I'm a local resident, and it's one of those things. A lot of people on the local Facebook pages now have been resigned to the fact that McDonald's are in there. No one's got a real problem with McDonald's as such, apart from the people that are really close. The concerns they've got with the late night opening is the area, the demographic is quite an elderly demographic. There are very few people in the area that will be local people that will be using that restaurant at night. So you're going to be attracting people from outside the area, which are generally younger people I was a young once, young idiots, to the area that are going to be bringing noise. They're going to go to the local parks to throw all their rubbish away, and they're not going to read a sign that says, please be quiet, please consider our neighbours. So the noise aspect, the prevention of crime, etc., and again, it's a moot point and it's a little bit of a, this lady will probably understand total technicality, but when you get all these delivery riders, they're all coming on these e-bikes now, which are completely illegal. And you are going to be bringing lots of little silent e-bikes come into the area on the delivery riders. I understand that all the mopeds, everyone has to be licensed and properly insured, but you're going to be bringing young people, and when young people gather, things happen. So we've got the problem with bringing more youth to the area, which are going to gather in the local parks, cause disruption, cause problems. And my biggest concern really is the traffic on the road. I know it's a traffic problem, but it's comes under, I think, public safety. When people are turning out of that McDonald's, turning right and turning onto the main thing and turning right into it, late at night, that road is awful. Cars are driving too fast, they're coming from town. It's the time of night where people are coming home from the pub and accidents are going to happen. So I would, if as we expect, the licence is going to be granted, I would like to see some sort of provision that rather than the McDonald's just put in the internal procedures that they've got, because all the procedures they've laid down are all about how wonderful the CCTV in the shop is and how wonderful the fire and safety in the shop is, but they're not actually looking at the community and trying to protect the community. There's very little in their thing about, apart from saying, when we get time, we'll do some litter picking. I think it's very weak on the community spirit, which they claim to portray. So as a minimum, I would expect some sort of coverage for anyone on the main road with a CCTV camera, which if they're as good as some of the stuff that I know is available, it would protect public safety. And it would mean that if there are any accidents, resolutions could be made. And if they're going to clean up the area, but the noise, if they shut up at 12 o'clock, I don't know what time the cooling off time is on the stuff, but there's still going to be staff milling around till 1 o'clock. And there's going to be doors opening and shutting, which I know the environmental people say there's no problem with the noise, but they're not the ones living next door to the place. So there are going to be cars opening and shutting quite late at night. So it's a bit rambling, so please excuse my rambling, but I think I've got my points across. But like I said, I do think it's going to bring a lot of disruption to the area, and there's very little mitigation that McDonald's have done to say, we realise we've come ballooning into the area, everyone's kind of resigned to it, nobody really wanted it, but that's a done deal. But now you're here, I think they should actually embrace the community and say, okay, we're here, let's work together, let's do some things that are good for the community, rather than just saying our very insular little cell is very tight and we're very secure within our own four walls. Because that's all, if all their representation is how good the internal CCTV and good the fire is. There's nothing about protecting the community or the neighbourhood. So stop there. Thank you.
Thank you. Councillor William.
Thank you, Chair. So I'll start by saying I'm here as a county councillor for St Mark's and St Peter's electoral division, representing my constituents. I've had considerable casework correspondence about this issue and this application. And I will start by saying the issue is not who the applicant is. It is the what, the where and the when of the proposal and the how of the regulation. The applicant is not yet trading, so there isn't any evidence about this specific site. So I'm very clear on that. But as a nationwide operator with a clear brand identity, wherever you go, it's the same. It's reasonable to extrapolate from issues elsewhere. And I think this is what the other objectors have done, and also what the community I represent have done. They have expressed the concerns that they read about in media elsewhere. So I am going to focus predominantly on the operating schedule. So the operating schedule is the only thing that seems to have been submitted by the applicant. It's fine words, but it really doesn't lend itself to good licensing conditions. It's a facade. If it was a building in Cheltenham, it would be grade 1 listed. But actually, in terms of enforceability, it's got the strength of wet tissue. If you look at the section 182 guidance, which you'll find bullet pointed on my additional information, you'll find that operating conditions need to be precise, enforceable, they must be unambiguous and clear in what they intend to achieve, If you look at the conditions, a lot of them are just woolly. So in contrast to the wording of your licensing policy, they're all couched in things like, oh, where it's practicable, where it's reasonable, where the applicant thinks it's reasonable. They have not taken heed of your council's own statement of licensing policy. Many of these conditions have far better versions in this council's own policy. And again, the Section 182 guidance says that you should look at the locality. So the applicant, at the top of their operating schedule, says that they want to work with communities. And despite the offer in my initial objection to seek mediation, which you can find on page 25 of the bundle, there's been no contact from the applicant. So perhaps the committee should consider whether the operating schedule is just hollow words. You have in the bundle, the additional information, some alternative conditions that you might wish to adopt or substitute onto the operating schedule. And I will try to address some of these here. Partnership working. So if the applicant had had regard for the locality and your statement of licensing policy, they would know that the council operates night safe and could join. Why wouldn't you? It's operating in the nighttime economy. Why wouldn't you? In terms of crime and disorder, the maps that I've submitted at pages 10 through 12 show that the area that I represent is an area of high deprivation. It's also an area of high crime. And there, the media articles are submitted to show that across the UK, contemporary media quotes across the UK, which on balance of probability are true, because whilst there isn't, there's criticism of media, but on balance of probability, if they weren't true, you've got the independent press complaints process, you've also got the courts for defamation. So let's take them as being true. The applicant has issues with antisocial behaviour across the UK. You will also know that in Gloucestershire, police resources are particularly limited, and therefore prevention of crime and disorder is more essential as opposed to trying to deal with it at the time. If you look at the CCTV conditions, you have heard what the officer said. They are not familiar with either of the certifications. And I submit on page 53 of the bundle onwards that the two companies mentioned, Callagate changed its name in 2009 and the following entity ceased trading in 2011. LGC Forensics is a bit more complicated, and eventually the company became Eurofins Forensics in 2017, but they don't seem to be doing anything to do with CCTV. You will also see in the bundle that the government has issued guidance, and there are numerous British standards about CCTV. So really you have to ask yourself, has the applicant submitted a condition that refers to certifications from companies that no longer exist, why they're not using British standard, and what is going on here? Because this does not seem right, given that the council also has in its licensing policy a far more robust condition. We would suggest that that should be substituted. Picture in the bundle shows that the applicant uses SIA door staff at other premises in town. Why is that not a condition that's required here? As the gentleman next to me mentioned, the applicant is known to offer a delivery service. And as evidenced on page 73, these deliveries will always occur during the hours of darkness. The committee will know from its own personal experience the issues in town with illegal vehicles being used, bikes with no lights on, things that look like bikes but are actually illegal electric motorbikes. Now, the licensing conditions are clear. The applicant cannot be responsible for the behaviour of people away from their premises, but it's their product being delivered to their customers handed to delivery drivers by their staff on their site. Surely they have a duty to ensure that those vehicles are road legal and have lights on at night when they leave the premises. public safety. The council is concerned about the safety of women and girls. There has been well-documented work by this local authority about preventing violence against women and girls. So why would the applicant not do something like offer Ask for Angela? It's a common scheme, it's in the nighttime economy. Why is the condition about no open alcohol not more prescriptive? It should say what happens if someone comes in, i.e. they will be asked to leave and they will not be served. That is measurable, that protects people. The condition that you currently have in the operating schedule just says they operate a no open alcohol containers policy. And what happens if they don't? Public nuisance, litter. So again, well documented, and the reference is in the supporting material. The council has a problem with urban gulls. So why not require gull-proof bins and include that in the conditions that come from the council's own statement of licensing policy? Noise. Again, the operating schedule's very wishy-washy on this. Where it's practicable to do so, we will encourage our customers. It doesn't say how. There are conditions in the policy. So you could ask for clear notices to be displayed in the car park and at the exits from the premises. That's pretty much what your condition says. You could limit the use of the outside area after dark or during the hours of operation. Light and odour. The applicant's operating schedule has said nothing about these, but they must know that these are issues. For light, again, there's a condition in your own statement of licensing policy that could be applied that says the light shouldn't cause a nuisance to adjacent premises. For odour, this is really difficult to evidence. I'm not sure how you present evidence of odour nuisance to a committee. But for those who have travelled around King's Ditch, you will be familiar with the very strong smell of cooking. Now, I invite you to consider what it would be like on a summer evening after 11 o'clock in a nearby residential property if you have to keep the windows closed because of the smell of cooking from the premises in that last hour. There's no conditions on this. Finally, I will turn to the protection of children from harm. Now, the applicant says, I'll read this, they do not anticipate that unaccompanied children will use the restaurant in the extended hours period. I think this is really, really naive. You've got people who are under 18 and people who their friends who are potentially under 16 who could come with them. The two media reports show that the premises are attractive to those who are still children, and this makes the premises attractive to those who seek to exploit children, whether child sexual exploitation or child criminal exploitation. The locality information shows that we're already in an area of higher risk of crime, and if you're aware of local things like Operation Endeavour, which is tackling organised crime, you will be aware of the need to protect children from exploitation. I will be very clear, this is a reflection on the society we are living in and not a reflection on the applicant. The fact that their premises is attractive is just down to society. But the applicant's staff, like so many in hospitality, are in the front line in defending children and vulnerable people from exploitation. So I would ask you, in the absence of a more robust condition, why not require the applicant to ensure the customer-facing staff during this last hour have done safeguarding training? We ask our taxi drivers and our private hire drivers on Borough Council to do that every 3 years. That doesn't seem overly burdensome, and it does seem like something that could be done, and you keep records to show that people are doing it. It goes some way to at least alleviating the concerns that you might have the issues similar to those that happened in Rotherham or I think it was Nottingham was the other one that I mentioned. So, in summary, the committee need to look at the Section 182 guidance and the Council's licensing policy and contrast this against a supplied operating schedule and decide whether the schedule is sufficiently adequate to protect our communities during this period of training. It's our submission that it is not. Further, the committee should consider why an applicant with all the resources of a multi-billion-dollar global organisation has put in an operating schedule that doesn't lend itself to the type of good conditions in the Section 182 guidance, and whether the applicant's operating schedule sufficiently promotes the 4 licensing objectives. Again, it's our submission that it does not. So based on this, the request is either to refuse the application, or if you are not minded to do that, to at least add or substitute Section 182 compliant conditions onto the licence. Thank you for your attention, Chair. Happy to take any questions.
Thank you, Councillor Willingham. Do members have any questions of the objectors? No. So I'd like to ask Mark Gallant or your legal representative, Sarah Claver, is it? Clover, is it? Yes, if you'd like to speak then.
Chair, thank you very much indeed. I am accompanied by Mr Mark Gallant, who is here as the representative for McDonald's, but I'm the barrister leading the charge, as it were, so I'm putting together the representation this evening. And thank you very much indeed for allowing me to do so. I think there are some fundamental misunderstandings with how licensing works in this slightly unusual arena of late night refreshment, which does fox people sometimes. So I'm going to unpack that a little bit, which will answer a lot of the points about operating schedule and conditions and why the application has been put together in the way that it has. It's always concerning to see anxiety coming forward from local communities and residents. McDonald's is no stranger to that, as you will probably appreciate that. That these applications have been going on for decades in one guise or another, obviously only slightly more recently for the Licensing Act itself, but communities have typically had some concerns about McDonald's as a global enterprise for various reasons. And the sorts of concerns that have come forward from the residents on this occasion are nothing new. And we see themes coming forward, antisocial behaviour and litter, and young people and so on, and healthy eating and some of the different things that have come forward. And what I'm pleased to start with by way of representation is to say that of the 1,100, more than that, outlets, McDonald's outlets in the country, and of the many, many applications that I have dealt with, we very often see objections like this to applications. We don't get any reviews. And that is a good touchstone as to whether the relationship that the community goes on to have with their local McDonald's bears out the fears that they expressed when the entity first came to the neighbourhood. Of course, McDonald's isn't a new entity to Cheltenham or anywhere these days. And you will get a very strong steer as to how to approach this application from your responsible authorities, who the Section 182 guidance makes very plain is your expert panel on any of the licensing objectives, be it crime and disorder, nuisance or safety, children, anything of that sort. If there were well-founded concerns about the application as presented, one or other of your responsible authorities would present that to you and give you a heads up as to what needed to be done about it. You don't have that in this case, and that's a very good starting point indeed. Some of the expressions of concern from the written objections and also coming from the floor today have been about McDonald's not being community-minded. That's not fair. McDonald's, perhaps more than many other outlets in their position, go to great lengths to be community-minded, perhaps to try to overcome some of this negative publicity and or reputation, particularly with things like litter litter picking. They go above and beyond also community engagement, community projects, community investment, and so on and so forth. This particular outlet will not be a franchise, as many McDonald's outlets are. This one will be owned by the company, so there is even that additional level of scrutiny. But I come back really to the fundamental point about this application, which is that it is for 1 hour of late night refreshment, and that presents certain constraints upon the decision maker. The application for the licence comes off the back of the planning permission, and that's also a very key consideration here, because although planning and licensing are separate regimes, the issues that they cover are commensurate. And so planning in looking at an application for the physical building and the impact on the roads and impact on local residential area, look at different terminology. They use terminology like residential amenity, whereas licensing uses terminology such as prevention of public nuisance or prevention of crime and disorder, but the actual topics, the actual issues are the same. And so this application, having been comprehensively through the planning system, the decision maker, this authority with a different hat on, were looking at exactly the same issues that the licensing decision maker will be concerned with comprehensively. And that decision maker is not constrained by the parameters of the regime within which they're working. So in other words, they get to look at what shall the opening hours be from the opening in the morning to the closing at night. And the planning decision maker has determined that it shall be 6 o'clock until midnight. So that's the baseline. And that baseline of 6 till midnight incorporates issues of noise, traffic safety, turning in and out of the unit, parking issues, congestion issues, congregation issues, all of the sorts of things that are raised by the residents in their concerns have been looked at already. It doesn't preclude you from looking at them, but obviously your position is that much more constrained because you have a single hour within which to work and upon which you could put your restrictive conditions should you choose to do so. Whereas the planning committee, the planning decision maker, had the entirety of the opening of the unit with which to deal, and they did so. And so on that planning permission, you have numerous conditions, planning conditions, which are authoritative and binding, beyond which the licensed entity could not go. And that incorporates the opening hours, it incorporates where parking shall take place. Critically, you might notice, because I think you've got the permit in your pack, you will notice it has a condition that takes care of nuisance issues, light and odour and noise, and the premises cannot begin to trade until they have submitted a scheme of operation that addresses those issues to the satisfaction of the council, and then within which those constraints the unit must trade. So they cannot create smell or noise or other impacts on the local residents that are antisocial in that sense. And so it would be duplication for the licensing decision maker to attempt to go over that same ground, and it would also be of limited utility because you could only do so in relation to 1 hour between 11 o'clock and midnight, and no doubt the planning committee took that into account when they made the comprehensive impositions that they did. And that fundamentally is going to be why you don't have any representations from the responsible authorities today, because they were also consultees to the planning application. The same statutory consultees are consulted. The police have an opportunity, environmental health have an opportunity, so they have already said what they needed to say about this venue, and they have imposed the restrictions that they see fit, and there is no need to do it again. You do have a core policy within your statement of licensing policy, core hours for restaurants. It's the closest analogy that you will have for a McDonald's, and the application falls within the 1 a.m. limit, so it meets with your licensing policy. And the operating schedule, therefore, is presented as indicative, as it can only be, because there is no point in imposing a licence condition that only has application between the hours of 11 o'clock at night until midnight. And the reason for those hours, of course, is because late night refreshment as a licensable activity is only a licensable activity between the hours of 11 o'clock at night and 5 o'clock in the morning, which means that from 5 o'clock in the morning until 11 o'clock at night, McDonald's could operate without any licence whatsoever. And there is absolutely nothing from a licensing perspective that anybody could say or do about it. So if McDonald's were not in front of the licensing committee for that hour between 11 and midnight, there would be no facility to put a licensing condition on them at all. Nevertheless, the operating schedule is McDonald's indication to you for your comfort and reassurance of the way in which they trade and the CCTV provision that they do have across all their trading hours and the way in which they do train their staff across all the trading hours and the staff safe system that they have and the litter picking regime that they have across all of the hours. And it's not just restricted to that hour. So the operating schedule is framed in the way that it is, specifically for a late night refreshment application of this sort. And I hope, therefore, that you can see that it wasn't a mistake or an oversight. It was quite deliberate and perfectly commonly done. And the operating schedule, in actual fact, was put together by my very good colleague, Mr. Leo Sharalambides, who is one of the top experts in licensing in the country and deals with McDonald's all the time. I'm actually standing in for him tonight. So I hope you will not take it as any kind of lack of alacrity in that operating schedule, but that you will understand that it was professionally done. That said, if the committee wished to translate any particular element of the operating schedule for the specific purpose of 11 o'clock to midnight, there's no particular objection to doing so if you have a particular requirement, for example, about CCTV. But I hope that the committee will be reassured that the standard of protection that McDonald's introduces to their units, whether it's CCTV or staff training or anything else of that sort, incident management, incident recording and so forth, is of the highest standard throughout the estate. It's not something that's simply drummed up for one particular application. As you will understand, consistency of quality of control and reputation is absolutely paramount for an organisation such as McDonald's. So one unit would not have a deficient standard relative to all the rest. It wouldn't have a dodgy CCTV system. They wouldn't fail to retain it for 28 days and so on and so forth. Just for the one unit, there is a standard and very highly sophisticated operating regime that applies to all McDonald's units. For that reason, it's not particularly easy to have individualised and bespoke conditions here and there and there and here. It is much easier for the McDonald's regime to have consistency that their staff and managers recognise wherever they may go, because obviously there's an element of fluidity and mobility amongst that staff. So I hope that assists. I'm conscious of time. I don't want to talk on and on, but I just want to touch on some of the things that we can delve into a little bit more deeply if the committee wish to do so. We've put in information about the Staff Safe Scheme. So you will see that McDonald's outlets are monitored from a central monitoring system. Staff in a store can press a button. It has various functions that they can draw on support and help if they need to, ranging from advice right up to emergency service immediate call out. The monitoring unit can observe what's going on in the store. They can play out recorded messages. They can play out live messages to people within the store to give instruction or tell them to stop doing what they're doing or tell them they're being watched and monitored or whatever else it might be. That is a sophisticated technical system that McDonald's uses. I hope you've also seen the 44-page booklet, the manager's guide in relation to antisocial behaviour, which gives you an indication as to the level of training that goes into that aspect. Nobody would be naive enough to suppose that McDonald's venues do not ever see issues of antisocial behaviour or more, but by the same token, they are very well versed in dealing with it. They know how to manage it, and they have training up front to do that. Litter, again, we wouldn't be sending out staff to collect litter in the dark between 11 and midnight. However, McDonald's have a very profound programme of litter collection. It's never just been their own litter. It has always been wider afar than just their own store. They go out several times a day. Mr. Gallant with me can address that in more detail if you'd wish to hear a little bit more about that. But that, as you would expect, is a very deeply embedded company policy. Deliveries, I think there was some concern about deliveries and delivery drivers. Obviously, you will appreciate that even if there were any question of imposing conditions, conditions can only relate to the impact of the licensing activities themselves. You can't impose conditions that relate, for example, to the type of bike that a delivery driver would use, but I'm sure the committee knows that. But delivery, McDonald's, being the entity that it is, has more advanced control over delivery drivers and their delivery partners perhaps than most, because they have quite a high degree of commercial bargaining power with the likes of Uber or Deliveroo and so forth. And if they find that a particular delivery partner's delivery drivers are not behaving themselves, McDonald's can exert that pressure and say, we will not use you if you do not, as a delivery partner, get your drivers under control. And some of those delivery partners take that to further extremes for themselves. They have got technology whereby, for example, they can prevent delivery drivers from accepting orders on their handheld devices within certain areas to stop them congregating here or there or wherever. They can put a black net around a particular physical location and say, you don't wait there, you can't stay there, you must go here or here, which is going to be less of a nuisance to the local demographic. And this particular McDonald's store, you might see from the plan, has got a McDelivery area in one of the corners of the store, which has been particularly selected to divert delivery drivers to wait in that particular place, to come indoors and not loiter outside where they might have the propensity to create more noise, and to wait under a certain amount of supervision for the orders that they're collecting before they go away. And finally, perhaps on that point, the closest neighbour, I believe, or certainly one of the closest neighbours, is Premier Inn, who have their own reputational issues to deal with about having a good night's sleep. And we are pleased to note that Premier Inn has not put in any kind of objection. They are satisfied with the proposal here for a McDonald's. It does replace a TGI Fridays, not like for like as such, although TGI Fridays had alcohol, which sometimes gives rise to different sorts of issues. They will, of course, have had people arriving and leaving and traffic and so on and so forth. So Premier Inn have had a certain amount of experience with a restaurant partner, as it were. And part of the reason for this application for McDonald's is that McDonald's will be serving Premier Inn customers. That is one of the symbiotic relationships that will exist and to a certain extent will carry on. And so for that hour, the hour that's being applied for, deliveries are important, Premier Inn is important, but it's highly unlikely to give rise to a honeypot effect of dramatic new footfall. That isn't the intention. But I can leave my submissions there, really, because you will know, and the Section 182 guidance makes it very plain, as does case law, that licensing is a permissive regime in its essence, saying yes unless it has evidence and reason to say no, and that would be reason that is causally connected to the application itself, not widely spread around the country. Previous applications going back 5 years or however many years that the news stories seem to relate to. But in terms of the application that is in front of you, you can take a certain amount of confidence in it, knowing that there is always the backstop and safety net for councillors, for residents, for responsible authorities, and pretty much anybody else who cares to take an interest to bring the matter back for review. And so I finish where I started, that I'm pleased to be able to confirm to the committee that that is not something that McDonald's sees, although there is that protection in case any of these anxieties and concerns manifest themselves in reality once the licence has been granted and the application begins. It is very rarely, in fact, never used in fact. And it's under those circumstances, it is that review facility that allows anybody to say, that is what is going wrong. And that appears to be why. So now we need to impose that particular control, whether it be in relation to noise or odour or children or traffic or litter or anything else. That is what is going wrong. And now, with evidence, we address and deal with that, rather than what is being presented to you this evening, which is a scattergun panoply of unsubstantiated concern, which in fact I am confident to make a submission to you will not come to pass. So unless I can assist you, unless Mr. Gallant can assist you, because he's the on-the-ground expert for any of these matters, that's what I'd like to say to you. Sorry.
Thank you very much. Right, do members have any questions of the applicant?
Thank you, Chair. Yeah, I've got a few actually, if that's okay. Okay, first one, I'm just wondering why this extra hour at this particular restaurant? That was one of my questions. And if you were to be granted this extra hour, is that something you would anticipate having it open till midnight every night, or would you see on the amount of footfall you get, or is the midnight that's it sort of thing?
I'll defer to Mr. Gallant for detail, but in broad brush terms, I touched on it. The hour connects to deliveries. It connects to, as you'll appreciate, McDonald's has quite a lot of detailed data around the country, and their market research is pretty sophisticated in terms of what the local area and demographic requires and supports in general terms. Obviously, COVID had quite a significant impact in terms of people's habits in drawing on delivery facilities. And so that is the match that has been identified for this particular store. There is also going to be a relationship with the Premier Inn customers as they come and go, and that final hour before perhaps they settle down for their night's sleep. And again, that's based on data and commercial practice and so on and so forth. Would it be for every night? My professional answer to that would be highly likely, because otherwise you create confusion in the minds of people visiting. Sometimes they expect it, sometimes they get it, sometimes they don't, and that can cause more trouble than it's worth. But can I defer to Mr. Gallant in case there are any more supplementary comments on top of that?
No, we would probably have to run it for 6 months to see how it proceeded in terms of deliveries and footfall. It's a drive-to, so it's not a drive-through, so that makes it slightly different. People are having to park the cars and get out and come inside, whereas delivery, you get it to your door. So we'd have to review it on a 6-monthly basis. But at the moment, it would be go for the midnight permanently until otherwise. Yep.
Did you have another question? Yes. Go through all your questions. Would you prefer the questions one at a time, or would, yeah?
Yeah, it's confused me, that would. Yeah. I think you said about, so how would you encourage visitors to remain quiet and mitigate against any possible public nuisance or crime and disorder? Because you can have signs, you can ask people, but I think this is touched on before, but, you know, how are you going to sort of try, you can't enforce it, but how are you really going to encourage that?
In terms of advising customers, then you're absolutely right. Notices is probably the only way it can be done, but don't forget the staff state scheme. So if you do have unruly visitors, and typically they'd be behaving in an unruly fashion outside the premises, coming into the premises, not particularly respectful to staff, not really behaving themselves, and then expect to walk back outside again. At that stage, staff have got the option of having that big brother eye, either to give a message in store, if that's going to have some kind of calming salutary effect, and if not, then emergency services or police or whomever can be called at that stage. It's not demonstrated to be a particular problem. It's one of those things that people raise. They expect it's going to happen. And you get pockets of issues here and there. But I think you can see from the level of even I appreciate the degree to which Councillor Willingham perhaps has collated any available stories, but if you relate that to the numbers of stores that there actually are up and down the country, and then the occasions where councils have had to draw a particular venue back in for some kind of corrective action, it's not perhaps quite as bad as people think it's going to be. But I don't know if Mr. Gallant can add to any of that.
Yeah, no, if you think we have 1,500 restaurants open every single day of the year, so if you magnify that, you know, the amount of sporadic antisocial behaviour or noise that you'll get from places is minute, really. We do put signs up, we do warn them. Obviously, we're in partnership with Premier Inn in terms of ensuring there's quietness on the site, because they have a thing as well. With regards to the couriers, we have a system when they come in. We have a tablet. If they're causing problems or not being respectful, not abiding by any laws of the road, etc., we can have them banned from that restaurant. So we have that facility to have them blacklisted, so they don't get any more jobs. So those are the sort of things that we have in place.
It is also perhaps just pointing out that the McDonald's Premier Inn relationship, this isn't the first time, it's not unique. So if Premier Inn, as quite a major organisation, had a problem with McDonald's on a typical basis, that is the last partner they would want next to them, because their reputation is built on a good night's sleep. So if they knew McDonald's to be problematic, they say, whoa, hang on a minute, anyone but you, and we don't want to be dealing with you, and we certainly don't want to be partnering with you. So I think that is also quite a useful touchstone.
Finally, one more, sorry. The other one is around about the litter. I believe you said staff aren't out collecting litter between 11 and midnight.
Yeah, I don't think they would. I'll get Mr. Gallant to check. But I think they go out during hours where it's safe for them to do so. So do you want to come back on that?
So for insurance purposes, we can't have them after dark or before sunrise to go outside of the restaurant. They can do the car park area if it's deemed safe to do so, and obviously if it's well lit, but they can't go any further than that during those periods, because what we tend to do is we have a system where we do 3 trash walks a day minimum, one at sunrise, one at sunset, and one during the day of larger amounts. So we pick up not only our own litter but everyone else's litter. That'd be fine, but we do in a circumference of the building that's safe to go to, and obviously the car park, if it becomes a problem, will be done as and when it needs to be done extra. But we do the minimum of 3, but for insurance purposes and safety, it's sunrise or sunset.
Yeah, I just think on that, I think that's obviously a lot of the residents, they're concerned if there's lots of litter, and, you know, if it's in the car park after 11 o'clock, you see, you know, staff see there's lots of litter been left, would they then go out and rectify it, because you don't want to attract vermin to the area.
So if I can answer that. More so with this particular occasion, because it's a drive-to, it's not like people are driving away, parking further up the road and throwing the rubbish out. Hopefully they'll be sitting either in the restaurant because they've had to get out of the car to get the food. And therefore, if there is going to be any rubbish, it's either going to be outside the restaurant, in our local sort of location, which we can then deal with. Yeah.
Sorry. I just have one question based on the litter pick, and that would be, when you do your litter pick, is it just within the area? So, for instance, there's a bus stop either side of your premises. If you found that there was regularly your litter, if I might use that term, in places like that, or perhaps just across the road, would you be doing that? I mean, I wouldn't expect you to do half the town, but if there were particular places where you felt that your rubbish was being dropped in a reasonable distance, would you consider doing that as well?
Yeah, of course. The manager of the branch will always, initially when he first moves in, will look at the area and see where he thinks there's going to be rubbish. If it's highlighted to him that there's other areas close by that he can get to, again, it's a risk assessment for the staff that you're sending, because they're away from the building and then they need to be in a sort of safe-ish area to pick up rubbish. But yeah, if there is, then we would do that. That's not a problem for us.
Can I point out on that? That's a classic partnership working thing. If the licensing officers of the council or environmental health or whoever had the remit for that came to McDonald's and said, we're noticing a particular issue, a particular problem, can we work with you on this? Would you address this? Would you address that? That is the sort of conversation I think that McDonald's regularly have in different areas, and they will work out something if it's drawn to their attention that there's a problem.
All right, because nothing to do with McDonald's, but I remember some little while back, and this might come to one of the comments that Councillor Willingham made. KFC, which is just across the road from me, and I was finding on regular basis whole bags of rubbish thrown in the subway just off. Now, it wasn't down to KFC, it was their rubbish, but some little hooligan had decided to take it out of their bins and throw it under the subway. I spoke to them and they were really good, and they cleaned it up on a fairly regular basis, which I thought was unreasonable in some ways because they shouldn't do it, but it is the sort of thing that happens. So security of your bins might be something that you'd need to take into consideration, because as I say, with the KFC, their bins were out the front, and I think youths were coming in for some ridiculous reason, decided it was a good idea to take 3 or 4 bags of rubbish and rip the bags open and strew it all over the public area.
So I believe we normally build a corral area where we store our bins, obviously for rodent protection and other things, so that they're kept within inside. They're not available to the public.
You'd like to think these young people had social media to distract them from throwing litter around, wouldn't you, in this day and age? But be that as it may, as you can imagine, these fast food giants have huge reputational issues around things like litter. They devote a huge amount of time and energy and money on addressing it. It's not a nice to have. It's absolutely fundamental to the operation because of this kind of situation. They come to make applications, or they come to open up in a place they've never been to before, and it's the first thing that everybody says, oh, well, what about you and your litter, noise, boy racers, and so on and so forth. So it's not something that has gone under the radar, if I can put it in that way, and everything that can be done is done, and typically, in my experience, a little bit more than they should be doing as well.
Okay, thanks very much. If there are no more questions, we'll go to, sorry, Councillor Sankey.
Sorry, I'm on a roll tonight. It's more of a query, really. You said that this McDonald's is going to be a McDonald's, not a
Franchise.
That's the one, franchise. What sort of difference does that make? Does that mean perhaps you're setting a higher standard there than perhaps a franchise would?
Not really, but I'll let Mr. Gallant take it.
There's no difference in terms of the standards that we maintain. Obviously, if it's a company store, it's centrally controlled. So head office, East Finchley, where I work, we have a consultant who works with that store, and that's part of our group of stores, if you like, that we do things in. We test new equipment or new products in different McDonald's company stores, and then it's rolled out to the franchise stores. But in terms of standards, in terms of the operating schedule and all the procedures, they're exactly the same, and they're maintained at that standard.
And it kind of has to be that way, really, for the reasons that I've given, this sort of global reputational thing. If one store is letting down the team, it has a seismic effect throughout the whole organisation. So in actual fact, the franchisees are under a huge degree of control, but that control ultimately comes from head office. So it's a different model of operation, but it isn't a different standard.
Right then, moving on to debate. Before I open for debate, I will remind you that it is important for you to give due regard to the council's licensing policy, and that if you deviate from the policy, you give clear reason for doing so. it's important that you only take into account material licensing considerations, and that your decisions are reasonable and proportionate and rational. So who would like to start the debate? Right, okay. I think, as I see it, we have, I think probably like all fast food outlets, there is the feeling that they're terrible places, that they're ruining our health, and they're responsible for just about every ill in society. Having said that, although you do put some good points in your operating system, I think some of the points that Councillor Willing was made was that, and if I can use a likeness with a major problem we used to have, because I've been a member of planning for over 20 years, more recently with licensing as well, and one policy that was always put on the big planning applications for estates was, will washing facilities must be provided? And they all provided them. A hose stuck by the gateway. Nobody ever used it. And I think what Councillor Willingham is saying, that some of those policies that are down, whereas you may do an outstanding job, you may not. So we would wish to see them tightened up. And I think I'm right in saying there was something about CCTV should be provided, not must be provided. I think I can be corrected if, I stand to be corrected if I've got the actual word, but it was things like that. The word should changed for must, and likewise with the quality of such things. So I might be asking when we adjourn that one or two of these conditions be just tightened up and the shoulds be changed to musts. There is a lot more that Councillor Willingham has given me a great deal of concern, because I do have a lot of respect for his views. I can't necessarily get my head around all of them, but I think what he was saying as much as anything is that a lot of the conditions are a little bit woolly and that we will need to tighten them up. But that's all I have to say in debate. Anyone else? No? Right, so we will be going to adjourn the meeting. I think it's best if you stay here. It's not at this point. Sorry?
Can we also check that the applicant has the final word and has all they wish to say before you depart?
Oh, yes, we haven't got to that
Thank
bit
you.
first. I thought, yeah, no, beg your pardon, I haven't got to that bit. Yes, well, the applicant hasn't had their final right to reply just yet, so.
So, Chair, if it's helpful, committee procedures, page 15 of the 5E licensing code of conduct. So point H, the objectors and their spokesperson or officials, or sorry, officers from statutory bodies responsible authorities will be given final right of reply. Then the applicant, licensee or their representative, so that's at point I, get final right of reply. And then it says the committee retires to debate the application and reaches its decision, if that's helpful.
Yes, I want to turn to our legal officer for a second.
Sorry, I'm a bit unfamiliar with the process because it's been a little while since I've done them. But the last time I did it, we did go to, before everybody sort of cleared up and went into the thing, that we did seek any final comments from the objectors, having listened to the applicant, and then the applicant normally has the final say before you retire to consider it. So perhaps if you want to do the objectors first, and then the applicant can scoop up anything that's been raised by the objectors. If they've got anything, they don't need to say anything. If they don't have it, it's no pressure. So, yeah.
Yes, my apologies. I thought there was something missing from the script, but never mind. So, Councillor Wing, because I was a little bit concerned, would you mind making those points again? Because I, for one, didn't quite get them. And then the other gentleman.
So what I was going to, so just to clarify the process, it's in your licensing code of conduct. It goes objectors' final right of reply, applicant's final right of reply, and then you retire. And I think the gentleman to the left of me might want to use his final right of reply before mine.
Right, beg your pardon. I wasn't listening because I was concerned about other things. So, yes, if you'd like to make your...
Sorry, it's just a few questions, and it might make sense, it might make no sense at all, but it sounds, from what you're saying, like you're trying to use this more of a delivery hub between 11 and 12 and supporting the hotel. Now, wouldn't it be beneficial, and I think the local community would be much more supportive if you said, we're going to open as a restaurant until the 12 o'clock, but the delivery, because you've got two other McDonald's in the area that are both in non-residential areas. You've got the Kingsditch one, which is completely out of the way, and you've got the one in the town centre. Wouldn't it be better to shut the window at 11 o'clock to give the locals a little bit of peace and quiet from the little buzzwalls going around on their mopeds, and then serve the hotel, which I think would be a nice compromise, but just do either restrict the deliveries or cut the delivery window at 11 o'clock, which I think would make a lot of people very happy. That to me is one of the points. Do you want me to go through all of them at once? There's only vague things. Oh, okay.
Just to sum up.
But that's just one of the things. The other thing is you put quite a lot of weight on it being acceptable because the planning people let it through first, but the planning people let it through because it was an application of TGI Fridays, and part of that initial planning thing was that if it was a rebranding, the highways actually reserved the right to look at the road layouts, which never happened and wasn't ever put into the planning thing. So some of the weight that you put on the planning application being a good way to say McDonald's is here and we've gone through a rigorous system is a little bit woolly. And again, it's through, we can't object to it, but I think it's gone under the wire a little bit. And some of the points are a little bit ropey. But yeah, and I think if you could do that, and if you could sort of, you've said about the delivery drivers, if you can find any delivery drivers that are on illegal bikes, whether electric bikes, electric mopeds, which I absolutely hate. I don't mind electric bikes you pedal. If you could guarantee that anyone entering your premises, you click that little button to ban them. If you could guarantee they were banned, I'd be a very happy bunny. So that's just my comments on it. But like I said, I think restricting the deliveries late at night would be an absolute top priority. I think also litter picking. We've got a couple of local parks, and when I was a lad many years ago, we used to go and pick up pizzas in Gloucester, drive to Churchdown, and guilty, Your Honour, the pizza things went all over the road in Churchdown. We've got a few local parks where people gather at late at night, and I think that's where, if you could do a weekly litter pick or something in the local parks, I'd be a much happier person. So if you could put your name on the local residents association thing, so when it goes wrong, they contact you, I'd be happy, but I'll stop there.
Councillor Willingham.
Thank you, Chair. So I'm cautious of going down the planning route because of knowing that planning and licensing are separate. But what I would say is that the the planning decision or the planning application was made in the name of BL Fixed Uplift Nominee 1 Limited and BL Fixed Uplift Nominee 2 Limited, not in the name of McDonald's. It was also a delegated decision. It never came before a committee. So the applicant, the true applicant, wasn't known, and it's been obfuscated. So nobody knew who it was. The applicant, in the objection, the applicant had the opportunity from the time of the objection until the hearing to contact me. My email address was on my objection, and I'm easy to look up as a councillor on Gloucestershire County Council. And they say they're eager to work in partnership with the local community. They could have taken the opportunity to try and explain some of this before and have that dialogue so that we had a better submission. They chose not to. Again, one might ask why. In terms of the CCTV conditions, we've presented evidence to suggest that neither of the two certification authorities, Callagate or LGC Forensics, actually exist anymore. None of you seem to know what this would do, and unfortunately the committee doesn't seem to have gone down the route of asking the applicant what the technical specifications, where you find this certification information and what these certifications actually represent. If you can't tell us what a certification gives you, it's pretty pointless putting a particular certification onto a licensing condition. I've done as good open source research as I can. I don't know what technical features, what this gives you. I would suggest that you need a British standard, you need something off the government website that defines what should be done for CCTV. The applicant has said they do 3 litre collections per day. Why not condition that? Not fewer than 3 litre collections per day as a condition. It's measurable, enforceable, what have you. Finally, I will say, as a councillor, I've got no formal legal or licensing qualifications. I am here just to represent my constituents. Conversely, McDonald's is a global organisation worth hundreds of billions of US dollars. The applicant has access to the best licensing barristers money can buy. Leo was mentioned. I know he edits the Journal of Licensing. You could say it's a case of David and Goliath, but I hope on this occasion you will side with David.
Thank you, Councillor Willingham. So if you would like your, well, if no one else has got anything first, you have your final right of.
Thank you, Chair. And just to say, this isn't a David and Goliath anything. This isn't a fight of any description. And I am going to pull legal rank a little bit on this because at the end of the day, these are legal proceedings. So I have to be forgiven for doing so. There are some legal parameters within which we are working and which the councillors and the residents are completely and utterly forgiven for not knowing, but it doesn't mean that the decision should not follow those legal parameters. So that is what I do need to focus on now, I have to say. The points that have been made about the planning permission are wrong as a matter of law. It didn't go under the radar. It wasn't obfuscated. The statutory consultees knew exactly who this application was. It was a change of use. It required planning permission upon which conditions could be put and were put. So nobody has slipped under the radar so far as planning is concerned, and planning has taken care of the lion's share of the potential impact on residential amenity, including most, if not all, of the issues that are before you tonight. That's a fact. The second fact is that planning is different from licensing in as much as you can't review it. So once planning has been granted, and Chair, with respect, you said sometimes conditions go on about wheel washing or whatever else, and they say they're going to do it and they don't. Well, that might be a problem in planning. It is not a problem in licensing, because licensees are whipped back in front of their determining authority, in front of the committees, on a knife edge. So you said you were going to do this, and you haven't. And now we're going to take your license off you, or we're going to restrict your hour, or we're going to add further conditions, or we're going to do this or that. And anybody can do that, including the residents. Any one of the residents can do that. So that is a key difference. And that is why the licensing regime as a legal regime is not front-loaded in the way that planning is. And it is a permissive deregulatory regime that does not need to identify every humanly imaginable condition up front and impose it in a volume of 20 lever arch files before an application can be granted. What is done is what is known in the licensing world as light touch. And if it is not necessary or proportionate to impose a condition, then it need not be done. And in this case, strange as it seems, whatever the committee were to decide to do in relation to conditions could only impact the hour of 11 till midnight. It would not be possible to control the hours of 5 o'clock until 11 o'clock. And so if McDonald's chose to have such and such a CCTV or chose to do such and such with litter, for those hours, there is nothing more that the committee could do about it. And that is why McDonald's comes forward with this positive, cooperative, community-minded operating schedule to say, this is what we're going to do, and this is how we do it, and this is consistent across the estate, and it doesn't cause problems elsewhere. So please be reassured. If the committee have a particular desire to impose a wording for CCTV, for example, there's no objection to it, but I would caution the committee to a degree in coming back with a panoply of conditions that are highly technical and detailed that can only restrain that 1 hour, because it's going to become complicated and it's going to be unnecessary. And if something in the future identifies itself as a particular licensing issue, then that can be raised in the first instance by the responsible authorities by way of partnership working, and McDonald's, I have no doubt, would address it in that way. And as a backstop, it could be addressed specifically by way of a review. And it is for that reason that the committee does not have a long list of pre-written technical conditions in front of you. And it would take quite some time and effort, I think, to come up with a technical list. If the committee are minded to do so, and there are some particular conditions that they wish to see, I might even invite the opportunity to come back and contribute to some wording, because the last thing I would want to do is give rise to unintended consequences by having a wording of condition that does not work for some reason. So perhaps that's something that we could take a further look at if necessary. But of course, my primary position is that it's not. Those are the points that I would wish to raise. Was there anything else you wanted to do? Thank you.
Okay, thank you very much. So now we will go and make our, we will adjourn. Oh, sorry, that was just a cough, was it? So I think if members and Lee will, I think, probably use the members' room. We say by 1:45, we'll be back, if that's okay. Right, thank you, and welcome back everyone on the YouTube channel. I think we've had a long discussion over this. Sorry it was a little bit longer than expected. And if I can ask the legal officer to read our decision.
Thank you. Just for the avoidance of doubt, this is the decision of the committee. My role within it is just to advise them on the relevant pieces of legislation, but the committee has asked me to read out the decision. So to confirm, at the hearing this evening, the subcommittee has heard from licensing officer, objectors, a representative for the applicant and the applicant themselves. The subcommittee noted that no representations have been received from any of the responsible authorities. As part of the deliberations tonight, the members have considered all of the written submissions that were made in respect of this application. Probably what I should have said, as I note somebody's busy trying to write it down, we will confirm this all in writing. The subcommittee had due regard to all of the relevant legislation, and in particular the Licensing Act, which confers powers onto the licensing authority to deal with applications. The committee also considered its obligation to promote the 4 licensing objectives. And in coming to its decision, took into account the Council's statement of licensing policy and the statutory guidance. The committee is aware that it must carry out its functions with a view to promoting the 4 licensing objectives as set out in the Act, and that the subcommittee cannot take into account representations which do not relate to one or more of those licensing objectives, and acknowledges that representations should be relevant and evidence-based. In addition to the written submissions, the subcommittee took into account all of the submissions that were made to the committee this evening. The subcommittee also considered the applicant's operating schedule. As a subcommittee, it sympathises with the concerns that have been raised by the local residents and by Councillor Dr. Willingham. But the subcommittee is mindful of the limitations that arise from the application, given it is for late night refreshment only between the hours of 11 p.m. and midnight. The subcommittee, therefore, by a majority decision, has decided to grant the application as requested. The committee, however, note that at the meeting tonight, the applicant has made a number of statements about the measures that they will put in place. The subcommittee expect that the applicant will adhere to good working practices and would anticipate that if there are problems, an application for review could be lodged and potentially more stringent conditions applied. With regard to the decision tonight, all parties are reminded that there are rights of appeal against this pursuant to the Licensing Act, and that any appeal must be made to the Magistrates' Court and commenced within 21 days of notification of this decision. As I confirmed halfway through me reading this out, this will all be confirmed in writing to all of the parties and to those who have made objections. And that concludes the decision of the committee.
Thank you very much, and I think that brings us to a close. We have, excuse me, it was only the one item, and there are no other items that the chair determines as urgent. So that at 8:05, I'll call this meeting to close.